Hello everyone. So now we're starting out with the second half of this chapter, that is known as your internal and external aids of interpretation. So we've just completed the principles of interpretation, the 8 principles, and now we're moving on to something known as the internal and the external aids to interpretation. So what exactly do we understand when we say internal and external aids to interpretation? It's a very simple concept. Like I said, the legislature makes the law, correct? Now obviously the legislature will not make the law so as to completely leave us in the dark, as to try to understand what exactly they mean or what exactly they seek to achieve by passing such a law. So what they will do is they will keep certain aids within the context of the law itself, which will help us to understand, okay, this is what the legislature meant when they wanted to give effect to the law. These are the exceptions, or these are the exclusions, or these are the inclusions. Everything will be present within the aids to interpretation itself. Now, whether these aids are present within the wordings of the statute itself, or are we to look somewhere outside of the law, is the difference between your external and your internal aids of interpretation. So let's start out with our internal aids to interpretation. The internal aids to interpretation, the very first thing we look at is your title. So the title of the act itself is admissible as an aid to construction. Now what do I understand by this word aid is admissible as an aid to construction? Okay, so what do they mean by this is that, remember we took the presumption that, or the presumption exists as to the validity of a law. That is, the legislature knows the state of the law that it is passing, and that all the words are to be interpreted as it is and should not be constructed loosely. The entire law should be read as a whole, and there is always a presumption in the validity of the law. So if some person is coming and challenging, saying that no, this interpretation causes repugnancy, or it is unreasonable in nature, or it is violating the purpose and the objective of the act. If a person is coming to claim such things, then he has to provide evidence before the court of law, and one such evidence that he can present before the court of law is certain internal aids to interpretation. He can claim that, Your Honor, the title says this, and hence the argument will follow. So this is what we call as being admissible in a court of law. That is, when you are alleging something and you are proving that point before the court, then that will be admitted as evidence into a court. And so the court will not just expect oral or physical evidence, it will also look at whether the interpretation of the law itself can help support his argument. And so they say that the long title of the act and the short title of the act is also admissible in the court of law. So what exactly is the long title of the act? In general terms, we can say that the long title of the act helps to understand what is the general terms, the purpose of the act, and it exists before the preamble itself. Okay, so the long title is in its essence a title, but it also helps us to understand what exactly that law is about. The short title is only used for abbreviation purposes. That is, to call the law something, we use the short title. The next one is the preamble. What is the preamble? The preamble is basically that part of the law which helps to ascertain what the object of the law is, what the purpose is, what it seeks to achieve, and how it plans to do so. Now, if it is a law that is merely codifying the unwritten law, then it will say that this is a law that is meant to codify all of the principles under insolvency code. Or if it's a consolidating statute, it will say the preamble will say this is a law for the purpose of consolidating and amending all existing laws under the Companies Act. So the preamble itself will be an introduction to the law. Now, is this preamble admissible in a court of law? The court is saying that yes, it is admissible in the sense that if the main provision of the law, that is your section 3 or section 4 or whether it's section 15, if that part is clear and unambiguous, that is, if it is clear, then the preamble cannot be used as it cannot be admissible in a court of law. Whereas if the enacting part is ambiguous, then you can refer to the preamble. So what do they mean by over here? When you are reading the provisions of the law, it is the literal interpretation of the law. You have to read it as it is. But if it is causing some kind of ambiguity, then the judge can refer to the preamble of the law so as to understand what is the real object of passing that provision. So it's very clear, the preamble can only be admitted as an aid to interpretation if the enacting part of the law is ambiguous in nature. Okay, and that's exactly what the court held in the case of Kamlapur Kochuni versus State of Madras. The heading and title of the chapter may simply be referred to by the courts for the purpose of resolving doubts as to the ambiguous words used therein, and they cannot restrict the plain and ordinary meanings of the words in the chapter itself. The next one is known as marginal notes. What is marginal notes? Marginal notes are like notes on a paper. Say for example, all of you all have your textbook and you would like to make a small note on the side so as to help you understand that point that you're reading better. Just like how we have these kind of notes, I can say the same concept applies to marginal notes. Marginal notes are a type of note which is attached to the law itself, whether it's the constitution, whether it is a normal law, etc. And they are used for the purpose of helping us to understand the provision of the section itself. It might be a clarity, it might be a note, it might be an explanation, it might be a illustration. Marginal notes are simply used to help understand the law itself and to help make its meaning clearer. Now, in the Supreme Court in Western India Theatres Limited versus Municipal Corporation of Pune, they held that a marginal note cannot be invoked when the meaning is clear. So just like preamble, only when the meaning is not clear in the law can you refer to the marginal notes. So they're saying that where the main provision is sought to be interpreted differently, reference to a marginal note would be permissible in law, but otherwise marginal notes may not be relevant for decisions in all types of cases. So we can say that marginal notes are for the purpose of helping us understand something better, whereas preamble is a type of a introduction to the law itself, which helps us understand what that law exactly is trying to achieve. The word proviso. The word proviso is, in simple words, I'd like to call it as your exception clause. It is the exception to the general rule. So we all know that just because one rule is applicable, does it mean that it's applicable to everybody? The answer would be no, because there will be some exceptions. It can be whether it is in the case of a rule not applying to children below the age of 7 years of age, or this rule not applying to persons of unsound mind. There will always be the rule and then there will be the exception to the general rule. And provisos are the exception to the general rule. Okay? The word proviso will always start with the word provided. The sentence which is the exception to the general rule will always start with the word provided. Now you must understand that proviso cannot be inconsistent with the main statute. That means if you are applying a certain prohibition to a group of people or a particular product or a service, and for reasons such as causing harm to health, so such as cigarettes or alcohol or even psychotropic substances, drugs, etc. Now, it's a blanket ban. Nobody is allowed to sell or use psychotropic substances. Can you provide an exception for that rule? Can you provide an exception as so as to allow any one person to use chemically altering substances in your body? No. So therefore, the use of proviso should not clash or should not be inconsistent with the main law, but rather must be read alongside the provisions of that law. Okay. The next one is known as illustrations. Illustrations are simply examples. In simple words, they are examples. They help us understand certain meanings, because any concept when explained through an illustration or an example, it makes it so much more clearer for you to understand. And illustrations are also present within the ambit of the law. But can illustrations be admissible in a court of law? The answer is no. Because remember, it is only an illustration. It is only meant to help you understand the provision better. It is not a point of argument before the court of law. The word explanation and the word definition, or as you can see over here, the interpretation clause, both of them are in essence the same concept, in the sense that an explanation tries to explain the meaning of words, and this also applies to definitions. Okay, they simply try to explain the meaning of a particular section. However, what is the difference between a definition clause and an explanation clause? It's simply that the definition clause is applicable to the entire law, whereas the explanation is applicable only to that section which it is provided in. So an explanation need not be applicable throughout the law. That would be a definition clause. An explanation is applicable only to that section or even that subsection if need be. And obviously an explanation is read so as to clear up any ambiguity in the main section. Can it be admissible in a court of law? The answer is yes, because it forms part of the main law. The next one is schedules. Schedules are always forming part of the statute and are always read together of the statute while constructing it. So what are schedules? Schedules are merely attachments. You could not have put that format or that content in the main part of the law, so you are just attaching it as a schedule. So schedules are nothing other than a mere extension of the already existing law. Statement of objects and reasons. So the statement of object and reasons helps us to understand what is the purpose of passing this law. Why exactly did they pass this law? What was the objective of it? What remedy did they think to give? Was there already an existing remedy that did not work? So the purpose of statement of objects and reasons is to help to understand the purpose or the will of the legislature. And these are what you call as your internal aids to interpretation. So let's do a quick recap of all the internal aids to interpretation. First, you have the title, which can be short and long title. We have the preamble. The preamble is an introduction to the law. Heading and title of a chapter may be used in case there's ambiguity in words. Marginal notes are a kind of note so as to help give clarity. It must be only used when the main enacting portion is not being is ambiguous and is not clear. The interpretation clauses, that's the definition clause and the explanation clause, are merely giving an explanation to the meaning of a certain word which has to be used. While the definitions clause is applicable to the entire law, we can say that the explanation clause is applicable only to that specific section. Provisos are known as the exception to the general rule and usually start with the word provided. Then we have illustrations, which are simply examples. We have schedules, which is an extension of the law, and it is simply put over there so as to avoid making the law extremely lengthy. So you attach it as an attachment at the back of the law. And finally, we have the statement of objects and reasons, which is to help us understand the will of the legislature or the purpose with which the legislature has passed this law. Next, we're coming down into our external aids of interpretation. These are all of your points which are not there within the law itself. If you see the internal aids of interpretation, you can see that the title of the chapter, the heading of the chapter, or a proviso, explanation, definition, these are all things which are there in the bare reading of the law itself. But then external aids to interpretation are those points which are not available within the law, but rather are available outside of it. So the very first thing that we have to take into consideration is the concept of parliamentary history. That is, what were all of those circumstances, or what and all happened at the time that this law got passed? Did the law get introduced by a political party, or did it get introduced by a single member? Was it rejected by the Lok Sabha, or were changes made to it by the Rajya Sabha? Did it get passed as a law, and did it get was it amended later point in time? Whatever was the surrounding facts and circumstances surrounding that law becomes something what we call as parliamentary history. And parliamentary history is not just parliamentary history, but generally I would say that any kind of external aids to interpretation are only to be relied on if there are no internal aids to interpretation to help you with the matter. So if you see, parliamentary history is simply to understand again the will of the legislature. What were they thinking when they passed this law? It can be read together with historical facts and circumstances. That is, what were certain established practices that this law came to ban or prohibit or take away or regulate, or what were the circumstances, etc., that led to the creation of this law. So I'll actually read parliamentary history and historical facts and circumstances together, in the sense that in the second point, the court is entitled to take into account such external or historical facts as may be necessary to understand the subject matter of the statute. Reference to reports of committees. We know that at the time of passing any law or making any law, that certain committees can be set up for the purpose of getting data and to help understand how this law would impact the people, or what kind of a law should be passed so as to help the better governance of that subject matter. Now, committees are set up with the intention of seeking expert help. So there will be experts who are in the committee who will eventually give the report. But remember, the report given by experts or of the committee are not binding on the legislature. However, they do have a persuasive value in a court of law so as to understand what exactly was the background of the law. But are they enforceable in a court of law? The answer is no, just like parliamentary history and just like historical facts and circumstances. So again, please remember, everything in external aids to interpretation is simply to help understand the will of the legislature. They cannot be used as strong points to get the courts to pass something in your favor. Then, reference to reports of committees, reference to other statutes. Now, this word reference to other statutes can be seen from 2 points in law. One is reference to a statute which has no common subject matter, or reference to a statute which is of the same, forming part of the same system. Okay, so say for example, we have the Companies Act of 2013. Now the Companies Act of 2013 came after the Companies Act of 1956. So can I say that both of these laws are actually forming part of the same system? They're both governing companies, they're both governing companies. So this is what we call as pari materia, where if any provision of your Companies Act 2013 is silent, then we will simply refer to the provision in the Companies Act 1956 if it allows us to do so. So say for example the term producer companies. Producer companies are not defined anywhere in your Companies Act of 2013. but we still have many companies which have been incorporated as a producer company as per the 1956 Act. So, statutes which are dealing with the same subject matter or the same system and the reference to each other is called as pari materia. That is, statutes dealing in the same matter. It is not that two statutes must be identical, but rather they should be governed under the similar subject matter. This is what you mean by reference to other statutes. But remember, reference to other statutes doesn't always have to mean within the same system itself. You can always give reference to other laws also while giving an interpretation. And it's clearly said that sometimes when we give reference to other laws, then we're giving reference to it for the purpose of understanding our law as a whole, not to implement two separate laws into the system. So, reference to other statutes must only be done as a last resort, because it is to be presumed that the existing law itself has all the necessary material to give effect to this law, what we saw under presumptions. Dictionaries, the use of dictionaries, where the act itself does not define a certain word, then it is a simple case of referring to the dictionary meaning of the word to find out what exactly it means. Then we have the use of foreign decisions. Now, just like how in pari materia we gave reference to another statute under the same system, similar judgments also can take reference to each other. So, say for example, our courts have on multiple occasions taken reference to other jurisdiction judgments. Maybe if you are studying the company law principles, you may have come across case laws such as Lee versus Lee or Solomon versus Solomon, or even in our own jurisprudence when we are studying law of torts, we refer to a case law known as Rylands versus Fletcher. These are all case laws which have been decided by a foreign jurisdiction, a foreign court of law. And if our laws are silent on the same, then we can actually reference to other other decisions for the help of understanding what exactly not for understanding what the provision is, but rather to obtain or get obtain the principle and apply to our own country. Then we have public policy. Public policy is a set of established principles that is followed in our country as a form of public policy. So many times we will have the policy but not the legislation, and every time a legislation comes out, it is only because a policy already exists on that subject matter. Now, what do I mean by policy? Policy could be a policy on economic affairs, or on the monetary policy, or on industrial revolution, or on export matters, or on solar. Every time a government takes a stand on something, we'll call that as a policy. Now, right now, the policy of the Indian government on cryptocurrency is that it is neither legal nor is it illegal. But then, we do not have any legislation or law on the same, in the sense that we do not have any law legalizing cryptocurrency or making it illegal. So therefore, we can only rely on the public policy matter, that is, our government imposes a 30% tax on any earnings through cryptocurrencies. That would be the policy of our government, and that is also an external aid to interpretation. So let's do a quick recap over all the external aids to interpretation. We have parliamentary history, historical facts and circumstances, reference to reports of committees, and reference to other statutes. Under reference to other statutes, we saw the concept of pari materia, the use of dictionaries, the use of foreign decisions, and as a matter of public policy.